Judge ad hoc Charlesworth will make her solemn declaration by video link in a moment. All judges participating in the hearing, whether in person or remotely, are part of the composition of the court in this case. Before we start our oral proceedings today, I would like to pay solemn tribute on behalf of the court to the memory of two distinguished figures of the UN system and of international law who have recently passed away. Mr. Javier Pérez de Cuéllar, former Secretary General of the United Nations, who left us on 4 March, and Mr. Thomas Mensah, former judge ad hoc at the court, who died on 7 April. Born in Lima on 19 January 1920, Mr. Pérez de Cuéllar had recently celebrated his 100th birthday. His lifetime spanned the 20th century and the history of the United Nations. A lawyer and graduate of the law faculty of the Catholic University of Lima and a distinguished diplomat, Mr. Pérez de Cuéllar served his country and the United Nations in many capacities. Having represented his country in the Security Council in 1973 and 1974, he was appointed Special Representative of the Secretary General in Cyprus, a post he held until December 1977. In 1979, Mr. Pérez de Cuéllar was appointed as United Nations Under-Secretary General for Special Political Affairs. Elected Secretary General of the United Nations for a 5-year term beginning on 1 January 1982, Mr. Pérez de Cuéllar was re-elected in 1986 for a second term of office, which ended on 31 December 1991. Javier Pérez de Cuéllar was a tireless broker for peace. Through his diplomatic talents and perseverance, he contributed to the resolution of major crises and the settlement of some highly complex conflicts. From the ceasefire that ended the first Gulf War, to the withdrawal of Soviet troops from Afghanistan, to the conclusion of a peace agreement in El Salvador, and the implementation of the peace process in Namibia that led to its independence. As Secretary General, Mr. Pérez de Cuéllar made several visits to the seat of the court here in The Hague and always underscored the unique role of the ICJ in the peaceful settlement of international disputes. As President of the Court and on behalf of the members of the Court, the Registrar and the entire registry staff, I would like to extend our sincere condolences to the Peruvian people and government and the family and friends of Mr. Pérez de Cuéllar. I would now like to pay tribute to the memory of Mr. Thomas Mensah, former judge ad hoc of the court. Thomas Abogie Mensah, of Ghanaian nationality, was born in Kumasi, Ghana on 12 May 1932. After graduating from the University of Ghana in 1956, he continued his studies abroad, earning a first-class degree in law at the University of London in 1959, followed by a Master's of Laws degree in 1962 and a Doctor of the Science of Law degree in 1964 from Yale University in the United States. Having taught law from 1963 to 1968 in Ghana, Mr. Mensah embarked on an illustrious international legal career, which led him from the International Atomic Energy Agency to the Secretariat of the International Maritime Organization, where he served for more than 20 years as legal counsel and later as Assistant Secretary General. In 1996, when the new International Tribunal for the Law of the Sea began its functions in Hamburg, he was elected as one of its judges and then chosen by colleagues to serve as the tribunal's first president. Under his stewardship, the tribunal adopted rules and established procedures that have continued to serve it ever since. In 2012, he was chosen as judge ad hoc at our court in the case concerning territorial and maritime dispute, Nicaragua versus Colombia. Judge Mensah was a member of the Institut de Droit International, a titular member of the Comité Maritime International, a member of the Advisory Council of the British Institute of International and Comparative Law, and a member of the Standing Committee on Maritime Arbitration at the International Chamber of Commerce. Judge Thomas Mensah was not only admired for his intellectual acuity as one of the world's leading arbitrators on the settlement of international maritime disputes, and for his great sense of humanity, but was also well liked for his humor, genial spirit, and conviviality. He was one of the most prominent personalities involved in the peaceful settlement of international disputes in the past quarter of century. As president of the court and on behalf of the members of the court, the registrar, and the entire registry staff, I would like to extend our sincere condolences to the Ghanaian people and government and the family and friends of Judge Thomas Mensah. I invite you to please observe a minute of silence in memory of Mr. Javier Pérez de Cuellar and Mr. Thomas Mensah. I now turn to the proceedings in the case concerning the arbitral award of 3 October 1899, Guyana versus Venezuela. I shall recall the principal steps of the procedure in the case. On 29 March 2018, Guyana filed in the registry of the court an application instituting proceedings against Venezuela with regard to a dispute concerning, and I quote, the legal validity and binding effect of the award regarding the boundary between the colony of British Guyana and the United States of Venezuela of 3 October 1899, end of quote. In its application, Guyana seeks to found the jurisdiction of the court under Article 36, Paragraph 1 of the Statute of the Court on Article 4, Paragraph 2 of the Agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, to which I will refer as the Geneva Agreement. And the decision of the Secretary General of the United Nations, taken on 30 January 2018, to choose, pursuant to the above-mentioned provision, the court as the means of settlement of the controversy. On 18 June 2018, at a meeting held by the President of the Court, pursuant to Article 31 of the Rules of Court, to ascertain the views of the parties with regard to questions of procedure, the Vice President of Venezuela, Her Excellency Mrs. Delcy Rodriguez Gomez, stated that her government considered that the court manifestly lacks jurisdiction to hear the case and that Venezuela had decided not to take part in the proceedings. She also handed to the President of the Court a letter dated 18 June 2018 from the President of Venezuela, His Excellency Mr. Nicolás Maduro Moros, communicating the position of Venezuela. I will now kindly ask the Registrar of the Court, Mr. Philippe Gauthier, to read out the relevant excerpts of the letter of the President of Venezuela dated 18 June 2018. Mr. Registrar, you have the floor.
Thank you, Mr. President. I quote, Your Excellency, very respectfully, we inform that given that Venezuela did not accept the jurisdiction of the court in relation with the controversy referred to in the so-called application presented by Guyana, and that furthermore it did not accept the unilateral presentation of the mentioned dispute, there exists no basis that could establish, even in prima facie, the court jurisdiction to consider Guyana's claims. Under these circumstances, and taking into account the aforementioned considerations, the Bolivarian Republic of Venezuela will not participate in the proceedings that the Cooperative Republic of Guyana intends to initiate through a unilateral action. End of quote.
I thank the Registrar. By an order of 19 June 2018, the Court considered, pursuant to Article 79, Paragraph 2 of the Rules of Court of 14 April 1978, as amended on 1 February 2001, that in the circumstances of the case, it had to resolve, first of all, the question of its jurisdiction, and that this question should accordingly be separately determined before any proceedings on the merits. The Court thus decided that the written pleadings should first address the question of its jurisdiction, and it fixed 19 November 2018 and 18 April 2019 as the respective time limits for the filing of a memorial by Guyana and a counter-memorial by Venezuela. Guyana filed its memorial within the time limit prescribed. By a letter of 12 April 2019, the Minister of People's Power for Foreign Affairs of Venezuela confirmed the decision of his government not to participate in the written procedure and stated that Venezuela would, at an opportune moment in due course, provide the court with information in order to assist it, and I quote, in the fulfillment of its obligations as indicated in Article 53, Paragraph 2 of its statute, end of quote. On 28 November 2019, Venezuela submitted to the court a document called Memorandum of the Bolivarian Republic of Venezuela on the application filed before the International Court of Justice by the Cooperative Republic of Guyana on March 29, 2018. At this juncture, I should recall that the court does not include upon the bench a judge of the nationality of either of the parties. Guyana availed itself of the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc and chose Mrs. Hilary Charlesworth. In line with its decision not to participate in the current proceedings, Venezuela has not availed itself of the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc in this case. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, that same provision applies to judges ad hoc. Notwithstanding that Mrs. Charlesworth has been a judge ad hoc and made a solemn declaration in a previous case, Article 8, Paragraph 3 of the Rules of Court provides that a judge ad hoc must make a further solemn declaration in relation to any case in which he or she is participating. Before inviting Mrs. Charlesworth to make her solemn declaration, I shall first, in accordance with custom, say a few words about her career and qualifications. Mrs. Hilary Charlesworth, of Australian nationality, is the laureate professor at Melbourne Law School. She is also a distinguished professor and director of the Centre for International Governance and Justice at the Australian National University in Canberra. She has taught at numerous academic institutions around the world including Harvard Law School, New York University,